Joining here the public defender representing Mr. Smith. Mr. Smith, would you state your name for the record?
Chair Jermaine Smith Jr.
The motion.
Your Honor, we are asking that the court consider our request as indicated in the bond motion, and a few things we would like to emphasize and information that I received from my fellow counsel. Mr. Brown indicated that he and or Ms. Pate had spoken to Community Corrections and were able to confirm that Mr. Smith contacted the Community Corrections front desk and spoke to them about the about what was happening when he was in the exclusion zone. Yeah. So that's the first thing, and that so they were able to confirm that is the information I received. The second,
And I know this wouldn't be you necessarily. Mr. Brown came up at a bench conference, stated that I said I needed something in writing.
So it was my understanding from the notes that the agent said that he was going to say.
All right, guys. Now the real tension in this courtroom starts building fast. What began as a simple bond discussion is now turning into a full legal investigation. The defense is pushing hard, trying to prove one thing: intent matters more than assumption. But the judge is not easily convinced. Every word is being measured carefully. Suddenly, Community Corrections reports enter the conversation again. And this time, they change the direction of everything. Because it's revealed that contact was actually made during the incident. That single fact starts breaking the original narrative apart. And now, nothing in this case feels simple anymore.
Submit something to you directly, and I will take a look at that and give you the date that conversation.
Which conversation?
The conversation where the agent told, I do not recall if it was Ms. Pate or Mr. Brown, that they would submit something to the court directly.
You received anything from Community Corrections on this?
So on April 20th, I take it back, it was Miss Virgils spoke with Brian Levitt, who said he'd amend his bond report with updated information, and that he did not contact the client, that is, not contact the bond, or pardon me, the tether agency directly, and the tether company did not contact him, but client called Community Corrections. And there is a cut and paste of an email to Miss Virgils from Mr. Levitt that says, for clarity, I was missing.
But wait, guys. The courtroom confusion is just getting worse. Different reports are being mentioned, but none of them fully match. One version says one thing. Another report says something completely different. The judge is now demanding clarity. No more guessing. No more confusion. Attorneys start digging into dates. April 14th, April 20th. Every detail matters, because even a small mismatch can change the entire outcome. Then comes the shocking confirmation. The defendant did make a direct call, not to escape, not to hide, but to report his situation. And that changes the emotional weight of the case.
Informed prior to our conversation, Terrence Smith Jr. did not call JSG Monitoring, nor was he contacted by them. He called Community Corrections and spoke with the front desk officer regarding his violation and stated he was with his cousin helping him move. I will amend my report with that information as well as what else you.
But I don't have an amended report. I don't have anything.
So I was under the impression that that had been provided to Your Honor based on my conversation. If we could pass for a moment, then I will out my conversation with my colleagues. I will reach out to Ms. Levitt. I will also attempt to get a copy, original copy of the email so that you will have that as opposed to me just reading it from Mr. Levitt.
I the email from April 20th.
You don't have anything either.
I do not have an updated report. The only report that I have from Mr. Levitt, I received, looks like on April 14th.
So, right, I have is one dated April 14th. But I guess part of the change is basically the third or fourth paragraph down that he called community correction.
Now listen carefully, guys. This is where things get real. The defendant explains his side of the story in detail. He says he was helping his cousin move items, nothing criminal planned, but the problem is timing, and location, and restricted zone rules. The court doesn't just hear words, it analyzes behavior. And this behavior suddenly doesn't look like an intentional violation. It looks more like a bad decision made in the wrong moment. Even the tone in the courtroom starts shifting slightly, and the judge is now thinking deeper than before.
Corrections Day violation spoke to front desk stating he was helping his cousin move, which I don't think was contained in the original.
No, and I don't see that I have that language in.
Mr. Neal. That was sent to us on April 20th, or thereabouts. I don't have any timing on that or anything, but I get it. Okay, go ahead.
The second thing that we would like to add orally to our written motion is that Mr. Smith has had time to really think about this and his and what he could have done differently to not have been in this situation. He's taking responsibility. He indicates that he could have and should have gotten more information from his cousin before agreeing to help with the moving because he did not know it would be in the exclusion zone. He also states that he could have and should have left as opposed to staying area for the 8.
Then comes a turning point nobody expected. The defendant doesn't argue, doesn't fight. He admits responsibility. He says he should have asked more questions before helping. He says he should have left immediately when things didn't feel right, even if it meant walking away alone, even if it meant trouble. That honesty hits differently inside the courtroom, because accountability is rare in cases like this, and suddenly, the energy shifts from accusation to reflection. The courtroom becomes silent, fully focused.
Walked away as opposed to trying to get his cousin to, and what eventually happened, his cousin giving him a ride away from the exclusion zone. The last thing that he's learned, and he said, he and his cousin and his friends and some of his friends have not always been the best influence, and that he has really learned from this that the people that he thought were not for him, his parents, are really the people who have been for him, and that he needs to take their constructive criticism, and because they've been the people who have put money on his books, who have been supporting him with this. So he is asking that the court please consider as part of this that he learned a very harsh lesson, a very harsh manner, but that he has very much so learned this lesson, and that and that you will not see him in that exclusion zone again.
He's been in since when?
He has been in since April 13th.
Mr. Cook.
Your Honor, I primarily rely on the written response that adds a little bit to that. With that addition,
But the story doesn't stop there. It gets even deeper. The defendant starts talking about his surroundings, his influences, friends who misled him, situations that pulled him off track. And slowly, a pattern of bad environment starts appearing. But then comes the emotional part, his parents. The only people consistently supporting him through everything, money on his books, constant communication, real support. And that realization changes how the court views him, not as perfect, but as someone learning the hard way.
additional report somewhat corroborate about the defendant helping his cousin move. I think that does give the people a bit more, trying to think of the proper words to use here. I think that helps lessen my concerns as it comes to the victim's safety with that additional information provided from community corrections. Really, so it comes from the defendant, but at least shows that he did contact them day of. I think if the defendant were to be released on tether, I understand the victim is not at that original address anymore. I think only time it might be goes to the middle of the round. Just reinstating the bond as it was versus I would feel fine with either that.
But prior to this occurring, we had not had any violations. He was on a tether where he could move around.
That is correct.
I believe that's correct.
Okay, fundamentally, the issue for the court was that certain things were said. The other report did not show a call from this defendant to community corrections or anything. Didn't say that he did anything. And I think I brought that up.
Now the prosecution steps in again, but the tone has changed. They admit the new information actually reduces some concerns, especially the fact that he contacted community corrections himself. That shows awareness, even in a mistake. The victim situation is also clarified. No direct immediate threat. So the risk level is no longer as extreme as before. The judge listens carefully, analyzing every side equally. Because now this case is about judgment, not just violation. And the final decision is getting closer.
It's the last hearing we were at. I saw nothing that he then did. What it seems that it turned out is that he did do something. He probably should have called JSG, but that's okay. He called community corrections. So that's a big change in this court's mind. But the other thing that's a big change is that there was nothing that verified why the defendant was in here. One story, but there was, at the time of the hearing, it was being said, but there was nothing that indicated that he had told anybody that. What's clear to me is that at least contemporaneous with the encroachment into the zone, he then calls, says, "This is what I'm doing." Doesn't seem to me under those circumstances that that's something that's made up. Plus, he's in that zone for what could be a significant period in time, depending on what he's up to. But it wasn't as though he went into that zone and spent half an hour. That's not this case. The problem is and I hate calling people this, but what you did was just stupid. what Mrs. Gaines says is what she should have realized, and that is you go in, it goes off, you get out. You just go.
All right, guys. Now the courtroom reaches its final stage. The judge starts summarizing everything that has happened. Yes, a violation occurred. That is not denied anymore. But intent, timing, and behavior all matter in sentencing. One critical mistake cost the defendant freedom temporarily. 18 days in custody, a punishment already served. But the court also recognizes the cooperation shown, and that becomes the reason for leniency. Everything is now leading toward the final ruling.
And that means somebody gave you a ride there, that's fine. But if you got to just hoof it out of there, you just get out. Understand?
Yes, Your Honor.
Because see, because of this, you spent what, 17 days in?
18.
8. Okay. You spent 18 days in, and you didn't have to,
Yes, Your Honor.
right? So you got to use your head, right?
Yes, sir.
All right. What I'm going to do, he had admitted to the violation, and it is a violation. Granted, I'll sentence him to 18 days. Washington County Jail credit 18 served. His previous bond is reinstated with including all of its conditions. And yes, tether, I'm not going to make it home confinement. I'm going to make it location track home. I don't know if the home confinement does anything. All right.
Thank you.
And sir, you understand now what you have to do,
Yes, Your Honor.
right? Yes. All right. Keep the number to JSG and to, well, you know the number for community corrections, but get that number for JSG and keep it with you just in case. Okay?
Thank you, Your Honor.
You're welcome.
Thank you, Adam.
And finally, guys, the judge delivers the closing decision. The sentence is confirmed. 18 days already served in custody. The bond is reinstated, but under strict conditions moving forward. The defendant is warned clearly, no more mistakes allowed. One wrong move again, and consequences will be much worse. The message is simple but powerful. Learn or lose freedom. The courtroom tension finally drops, but the lesson remains heavy. And just like that, one mistake becomes a lifetime warning.